Hi folks, this is Ana Sofia Walsh on the IP Flow Show, where we talk about all things intellectual property. Our guest today is Ron Coleman, partner at Archer and Greiner and lead attorney of the Slants case. Welcome to the show, Ron.
Thank you.
Could you give us a little background to the Slants case? Why is it so hot right now?
In many respects, it's a perfect storm. We've got a lot of things going on at the same time. Very little of them have to do with my client. But the Redskins case has been working its way through the courts and through the PTO for many years in many different forms. And it happens to be coinciding with a moment in American politics and culture where there are these forces involving ethnic grievances and political valuation of ethnic grievances that place a great deal of value on, assigning great value to them. A great deal of importance is placed on sensitivity to historical wrongs, which are very real. There is, on the other hand, a greater appreciation for the value of intellectual property rights than has ever existed in history, even to the extent where judges and legislators and institutions recognized rights that had never been dreamed before, so that properties like NFL's team names have value that would have never been dreamt of by the framers of the Lanham Act. So all these things are happening at the same time, and then you've got my guy, one of many leaders of many rock bands. I suppose there are other kinds of bands as well, but for some reason, waltz bands don't seem to have these problems quite as often. Although I did write about a case involving a dispute between the heirs of the Glenn Miller swing band, which in its time was far more important than the Slants, and in fact far more important than the Washington Redskins in its time. Historically, the rights of musical bands has been a very big topic of litigation and of fights over trademark rights and the rights to names. But just about at the time when we hit the appeal system, the Redskins in one of their many cycles, and their most recent cycle, hit on a parallel track in the Fourth Circuit. Not really a mirror image, but a comparable moment in their case, and crazy things have been happening.
Do you think the Supreme Court will grant review?
Well, let's put it this way. I'm reluctant to talk about stuff that's happening in the case right now, but I will say that it is certainly a significant thing when a federal statute is deemed to be unconstitutional. On the other hand, we certainly think that the Federal Circuit got it right.
What's the relevance of the First Amendment for these cases?
I'll say this much. We've been heard quite a bit. We've had a lot of opportunity to brief these issues. We briefed them in the Trademark Trials and Appeals Board on one level. We briefed them on sort of the administrative law issues in our first go-round before the First Circuit Court of Appeals, and then we were instructed after that initial ruling was sua sponte vacated to just focus on the First Amendment issues. And so I obviously, considering that we're preparing our response to the cert petition, I'm not going to get into it, but I will say this. There's a lot at stake, because when you consider the positions that the government has found itself taking in order to maintain the right to pass on these applications, there's a lot in there that should trouble a lot of people, not necessarily people who are in favor of hurtful words, not necessarily people who are in favor of wealthy holders of extremely valuable trademarks, but people who are in favor of ordered liberty, and people who are in favor of limited government, people who are in favor of understanding congressional intent There's a lot at stake in this appeal, but then again, we do feel pretty good about the way the Federal Circuit put it in the opinion.
How do you think the two cases being considered at the same time has impacted the Slants case?
Well, there's no question that if it weren't for the Redskins case, this would be a much more provincial, much more local interest kind of case. I mean, at one point I was speaking after the decision, and on a panel, and mentioned that in our law firm, we have had the opportunity to ask ourselves the question, well, how do you market your success in this case to your clients? I mean, how do you say, well, good news, all those offensive or potentially offensive or derogatory or scandalous trademarks, or much less obscene ones possibly, that you had been holding back on registering, good news.
But at the same time, there are a lot of trademarks that have been registered that, for instance, variations on some obscene words but spelt differently, so there's a balance there.
Well, it's not only that, you're coming on to my point, which is that people like that are also getting registrations for trademarks that are in and of themselves completely benign. So the Klan might register a trademark for white cupcake, and you cannot deny a registration for white cupcake. And they might all decide, sniggering under their white hoods at some meeting, let's all white cupcake. That'll be our code word for really something really terrible. And they'll get a big laugh out of it, and they'll raise $1 million using the word white cupcake. You can't make the argument that anything that promotes bad things or helps bad people is going to now come within the ambit of the PTO. That's not what the Lanham Act is about.
Well, especially since they seem to be triggering mostly political or politically offensive terms rather than anything else,
Well, listen, considering what some people say about, what pro football does to pro football players, perhaps all the NFL's trademarks should be canceled, not just the ones involving offensive trademarks. Maybe because their activities cause concussions.
Sure.
Obviously, I'm not saying that. I like to watch big guys
run into each other.
Hit each other as parts to the next person.
Well, say the Supreme Court does grant review and does rule in your favor. How do you think this will affect the trademark landscape in the future?
I frankly believe that just as has been the case until now, it will have a very marginal effect. One thing that will happen, though, that I think is really important is, and I mean this in all seriousness, the PTO will be allowed to return to its mission of examining trademarks. The very fine people who examine trademarks have been asked and are being asked to do work that Congress, frankly, did not task them with. With all due respect to the agency, they are doing what they understand the courts have asked them to do, and when they're relieved of that burden, it's going to be as if they had never seen sky, sun, and trees before.
And on that note, thank you so much, Ron Coleman.
You're welcome. It's been a pleasure.
That was Ron Coleman, partner at Archer and Greiner and lead attorney on the Slants case. If you would like to see more content, please check out the IP Flow tab on mimesislaw.com. I'm Ana Sofia Walsh, and see you next time.
Cybersecurity is a massively complex, systemic issue. Both the private and public sectors are wrestling with it. These are threats that affect everyone around the world, from large institutions down to individuals with a credit card and a social security number. All of these issues around cybersecurity are complex in their own right, and the individual threats that we all face are as numerous as the institutions out there utilizing networks. Cypher is here to help you sort through these issues by covering the cybersecurity news of the day and bringing you the facts straight from the experts in the field. Just like the rest of the Mimesis Law network, Cypher will bring you primary source news pieces from the people who know it best. We'll help you sort through the constant stream of information to help you understand the challenges, the technology, the systems, and the cultures leading to the threats we're continuing to face. I invite you to join us here on Cypher, only from Mimesis Law.